Good afternoon to all. Thank you for joining as the Commission delivers this very important ruling. I am Dr. Donnelly Carrington, Chairman of this hearing, and I'm joined on this panel by Commissioner Dr. Anki Scott Joseph, Commissioner Samuel Wallison, Commissioner Rowan Martinez, and Commissioner John Griffith, as well as the CEO of the Fair Trading Commission, Dr. Marsha Adderley Aikechi. On October 4, 2021, the Barbados Light and Power Company Limited, the applicant, made an application for a review of electricity rates dated September 30, 2021. The Fair Trading Commission, the Commission, gave its decision on the application on February 15, 2023, the 2023 decision. On March 7, 2023, the applicant filed a notice of motion for a review and variation of the Commission's 2023 decision, supported by an affidavit of Mr. Roger Blackman, the applicant's managing director. The review and variation motion was heard in an oral hearing on August 28 and 29, 2023. 6 interveners participated in the oral hearing, namely Tricia Watson and David Simpson, the Watson and Simpson team, the Barbados Renewable Energy Association, Mr. Kenneth Wendt, Ministry of Energy, Small Business and Entrepreneurship, Business Division represented by the Public Council, the Barbados Association of Retired Persons, BAR, represented by the Public Council, and the Barbados Sustainable Energy Cooperative. The review and variation motion raises questions of error of law, errors of fact, and important matters of principle. The errors of law the Commission is said to have committed were set out as follows. The applicant alleged that, firstly, the Commission failed to discharge its statutory obligation enunciated under Section 10 of the Utilities Regulation Act to set fair and reasonable rates through its inconsistent application of the adjustments relative to the test year. Secondly, the Commission acted in excess of its jurisdiction and therefore ultra vires by directing the applicant to take certain actions regarding the SIF when it had no jurisdiction to do so and had previously acknowledged that it had no jurisdiction under its enabling legislation to oversee the SIF or to direct the applicant to take action regarding it. Thirdly, the Commission provided no written reasons or insufficient reasons or other reasonable basis upon which to conclude that it considered or properly considered the evidence submitted by the applicant on the matter of its prior referral of the withdrawal from the SIF to the Commission. Fourthly, the Commission provided no written reasons or insufficient reasons or other reasonable basis upon which to conclude that it considered or properly considered the evidence submitted by the applicant on the matter of its accumulated depreciation and its prior applications to the Commission for the approval of depreciation rates between 2013 and 2022. Fifthly, the Commission exceeded its jurisdiction and therefore acted ultra vires in its ruling on the treatment of deferred tax liability. Sixthly, that the applicant had a reasonable or a legitimate expectation that the $99.5 million withdrawal from the SIF would not be treated capriciously by the Commission based on the Commission's representation that the applicant did not require its approval. Finally, that the applicant had a reasonable and or legitimate expectation that its recording of deferred taxes as current year revenue for the year 2018 would not be treated capriciously by the Commission based on the Commission's representations to the applicant that the same should be done. The applicant contends that the Commission made the following errors of fact in its 2023 decision. Firstly, the Commission failed to properly consider the evidence submitted by the applicant concerning accumulated depreciation. Secondly, that the Commission failed to properly consider the evidence submitted by the applicant concerning the 5 megawatt energy storage device, referred to as the ESD. Thirdly, that the Commission failed to properly consider the evidence submitted by the applicant at Schedules F of the application concerning the capital structure. The important principles of law raised by the applicant in its review and variation motion were that, firstly, the Commission violated an important principle of regulatory rate-making by engaging in retroactive rate-making outside of the legally established principles about when this is appropriate. Secondly, the Commission violated an important regulatory principle by selecting a test year 2020 and then inappropriately using data from other years on a selective basis. Thirdly, the Commission violated the important regulatory principle of regulatory certainty and consistency by making a ruling on the SIF in its decision, which was contrary to a written direction given to the applicant on previous occasion on the same matter, of which the applicant reversal of opinion undermines public confidence and that of the applicant and other regulated entities in the stability of the Commission's decision-making process and prejudice the applicant. Fourthly, the Commission violated the important regulatory principle of regulatory certainty and consistency by making a ruling on deferred taxes in its decision, which was contrary to its direction given to the applicant on a previous occasion on the same matter, and which apparent reversal of the opinion undermines public confidence and that of the applicant and other regulated entities in the stability of the Commission decision-making process and prejudices the applicant. The applicant contends that as a result of the errors which the Commission allegedly committed, it is entitled to the following orders. 1. An order pursuant to Rule 55(1) of the URPR that the motion and the grounds upon which it is made meet the threshold test and that the Commission should review the decision. 2. An order pursuant to Rule 56(1) of the URPR granting a stay of those parts of the decision which require the applicant to 1. Declare a regulatory liability of $99.5 million in connection with the SIF fund. 2. Declare a regulatory liability of $9.5 million in connection with the deferred tax liability. 3. Revisit its accumulated depreciation expense. 4. Use base revenue, customer count, usage, and demand values from the period ended June 30th, 2022 for purposes of making an adjustment to the test year revenues and within the cost of service study. 5. Use a financial capital structure of equity 55% and debt 45% for rate-making purposes in the determination of the rate of return. And 6. To modify the as-filed test year expenses in the development of the revenue requirement in respect of utilizing the 2020 reported insurance expense of $8,198,082. The effective from the date of filing of this notice of motion and delaying the implementation of the decision until the determination of this motion or such later date as the Commission shall determine on the such conditions as the Commission may prescribe in the exercise of its jurisdiction under Rule 56(1) of the URPR. The Commission determined that the application for the stay would be determined by a written hearing. The Commission received the written submissions of the parties and rendered its decision on May 12, 2023, the stay decision, and thereby stayed various orders made in its 2023 decision. The applicant also requested the following orders. An order pursuant to Section 36 of the FTCA and that the decision is varied in part so that the Barbados Light and Power Company is no longer required to 1. Retroactively record 50% of its 2019 income tax gain as a regulatory liability and amortize the liability over a 15-year period. This is reflected in paragraphs 404 of the decision. 2. To retroactively establish a record of $99.5 million in a regulatory liability account to first deploy the monies recorded in the regulatory liability account in the event of a covered catastrophe event, and to refund its customers the SIF amounts withdrawn that are not redeposited into the SIF over a 30-year amortization period as a reduction to insurance expense that should be shown as a separately identifiable amount for regulatory reporting purposes. 3. To retroactively establish a regulatory liability to recognize the difference between the accumulated depreciation recorded using the approved regulatory depreciation rates and the accumulated depreciation recorded on the depreciation rates the Barbados Light and Power Company used for its financial statements. 4. An order pursuant to Section 36 of the FTCA that the decision is varied so that the test year is updated to 2022 in its entirety, including non-depreciation expenses and construction work in progress. 5. An order pursuant to Section 36 of the FTCA and that the decision is varied so that the undepreciated portion of the 5 megawatt energy storage device and operating expense is recovered in the rate base. 6. An order pursuant to Section 36 of the FTCA that the decision is varied so that the financial capital structure of equity 65% and debt 35% is used for rate-making purposes in the determination of the rate of return. 7. An order pursuant to Section 36 of the FTCA that the decision is varied so that the cost of the insurance utilized in the development of the revenue requirement be filed as $12,348,641. After carefully considering all the evidence properly before the Commission and all submissions, both written and oral, from the parties to the motion, the Commission's decision is as follows. 1. The Commission is satisfied that the applicant's review and variation motion met the threshold test as required by Rule 51(1) of the URPR. 2. The Commission did not act in excess of or without jurisdiction by directing the applicant to take certain decisions concerning the self-insurance fund. The Commission is satisfied that, in addition to other powers specified in its decision, the obligation imposed on it or the power given to it by Section 10 of the URA to fix rates which are fair and reasonable gives it jurisdiction to treat to the over-collection of the funding of the SIF. 3. The Commission finds that on a true construction of Regulation 8 of the SIF regulations, it is unlawful for the applicant or the trustees of the SIF to use money in the SIF to pay dividends to its shareholders. The Commission found as a fact or a question of mixed fact and law that the applicant did not establish itself as the source of funds which were used to build up the SIF. The Commission is of the view that it is impermissible for the applicant to use money collected in rates from customers for deferred tax liabilities to pay dividends to its shareholders. The Commission is satisfied that the creation of a regulatory liability is reasonably necessary or incidental to the rate-making power of the Commission. The Commission is satisfied that it has power to declare a regulatory asset or regulatory liability as part of its rate-making power to ensure that the rates are fair and reasonable at all times. The Commission rejects the argument that it engaged in impermissible retroactive rate-making by its orders concerning the SIF, deferred income taxes, and by selecting a test year and allegedly inappropriately using data from other years on a selective basis or otherwise. The orders made by the Commission do not amount to retroactive rate-making, or there are exceptions to the rule against retroactive rate-making. In the case of deferred income taxes and the withdrawal from the SIF, the Commission is dealing with the unforeseeable and extraordinary overcollections of revenue, which are recognized exceptions to the rule against retroactive rate making and are not regarded as retroactive rate making. 7. The Commission similarly rejects the applicant's claim for legitimate expectation and/or estoppel arising out of the alleged representations made by the Commission to the applicant concerning the SIF and the overcollection of deferred income tax liability. The Commission further rejects the applicant's grounds that the Commission failed to consider or to properly consider the evidence submitted by the applicant concerning the accumulated depreciation, the ESD, and Schedule F of the application concerning the capital structures. The applicant's request to recover the undepreciated portion of the 5 megawatt energy storage device and the operating expenses in the base rates is denied. The costs related to the ESD will continue to be recovered through the fuel clause adjustment. The Commission will formally review the applicant's compliance filing, require amendment as is necessary, and therefore issue the final order outlining rates. It is hereby ordered that the applicant's review and variation motion is dismissed. The order of the Commission made on May 12, 2023 at paragraph 33A of its stay decision specifying the specified orders of the Commission's 2023 decision is hereby lifted. Interim rates are to continue to be billed through to the date determined in the final order. The issue of refunds, if any, will be addressed in the final order. The Commission thanks all parties for the participation in this proceedings, and full details of the Commission's decision will be published on our website, ftc.gov.bb. Thank you, and have a good afternoon.
That the final order is still to be made regarding rates, right? So we don't have any idea how soon.
Well, the process should not be that long, in that the applicant, as part of our 2023 decision, had complied with the Commission's request to submit their compliance filings. So we will now be in a position to review the compliance filings that was submitted by the applicant, and if there are any amendments to be made, we would direct the applicant to make those amendments. So the process should be short, because we already have in hand the compliance filing that was based on the 2023 decision. So, and that, since we are reverting to that decision, then that compliance filing would be in order, but we will check now to ensure that it is correct. So that is the process we will go through now, to ensure that what they have submitted is true and fair, and we will therefore be in a quicker position to make that final order. So we anticipate that we should be able to do that fairly soon.
But that, however, is conditional on the applicant responding to us if there are any changes to be made within a relatively short time.
So consumers should hear finally what they have to pay on what they, before Christmas.
Yes.
What would you say to those members of the public and other people who have said that this matter has taken too long, given that the application was filed since October 2021?
Well, basically, you know, we go through a process in terms following the actual rules, because a hearing is set out in our regulations and according to the law. So you would have a process in which persons will submit, you know, applications to be interveners. We have to go through that process to ensure that they meet the requirements. The interveners go through a process of asking questions of Light and Power based on the application. The Light and Power was given time to respond to that particular process. Then it was the whole question of establishing the dates for the actual oral hearing, and so these things do take some time, and we have to follow the rules as outlined in the URPR. So to some extent, it is basically as a result of those rules.
If I can add to what Dr. Carrington is saying, a rate review is a very complex process. There is much back and forth that needs to take place, and we must give persons the opportunity, particularly interveners, the opportunity, as well as the applicant, the opportunity to have any of the questions that they've raised thoroughly ventilated. So that takes time in and of itself. We must be cognizant of that.
The documentation is thousands
Yes,
of pages.
we had, I believe, over 3,000 pages of documents, and that was just for the first part of the rate review. That was probably multiplied by 2 as we go into the second part. So it was an intense and very complex process. And the Commission takes its responsibility very seriously. So we must ensure that we take the time to go through the documents, to analyze and reanalyze what is presented to us, so that when we issue a decision, we believe that we can stand by that decision and that it is in the best interest of both parties.
So we're gonna get copies of your presentation?
Not so much his presentation, you will have a copy of the full decision, and you will also get a summary as well.
Okay.
You'll have that.
You ready?
Yeah,
Okay.
yeah, it's already. Yeah.
Thank you.
The only other thing I would add is in relation to the ESD, because that has been a source of some considerable discussion. The ESD energy storage device, and that specifically relates to the install plant at Trent, that has been recovered, or it started to be recovered a few years ago through the fuel clause adjustment. The applicant requested that it be transferred to the rate base. The Commission has denied that. The applicant initially requested that be recovered through the fuel clause adjustment, and we are of the view that it should continue to be recovered through that mechanism. So the Commission is in no way questioning the prudence of the investment. We are simply saying you will continue to recover it through the means by which you asked originally. We have not seen any challenges with recovery through that particular mechanism. It allows for us to be very transparent and to monitor much more closely, and we believe at this point in time that that is the appropriate mechanism through which it should be recovered.
Thank you.
Right.
Just have one final question, and it has to do with the frequency or lack thereof of rate reviews. There's been suggestions that those should happen more frequently. Is there anything within the law under which the FTC functions that permits that, or would there be a need for a change in legislation or anything to facilitate more frequent rate reviews of this nature?
On the legislation, on the Utilities Regulation Act, a customer can initiate a rate review, the applicant can, or the Commission can. The specific thing about utility regulation, that there's a symmetry of information. Everything that we do is predicated on the availability of information. The reality is, invariably, the utility has most of that information available to it. Even in terms of reporting, they report to us. We have to do our checks that we need, that are necessary, but ultimately, regardless of whether you're speaking of Barbados, this jurisdiction, or any other jurisdiction, that is one of the shortcomings of utility regulation, the asymmetry of information. It will be difficult, not impossible, for the Commission to initiate a rate review, but the reality is it would be a little bit more difficult for us to do that than to allow the utility to come. The utility at any point, once they believe that they are financially challenged or likely to be in the future, can initiate that review. It is, yes, and it's also an extremely costly
Costly
exercise.
That must be borne by the rate
By,
payers.
by the ratepayers,
Payers.
yes. One of the ways that we are seeking to address that going forward, you would have seen that we recently issued a clean energy transition rider. And that is supposed to assist with the quick recovery of costs related to the expenses associated with the transition. The expectation is that that would allow for us to be able to make determinations much faster, because the rubric, the basics for on which any costs will be approved, those have been settled in large measure. It will be looking more so at the prudence of the specific investment. The chairman is asking for me to indicate there's another mechanism for rate review. Under Barbados Light and Power's current process, that is under at a rate of return type of mechanism. There's also the price cap, which is done again about every 3 years or so. But that allows for an adjustment in rates on a specific percentage annually. So you would invariably from time to time see a change in cable and wireless's rates, and they would put a notice in the paper, but not having gone through the initial process. But the maximum is set at a specific time of a review, and within that review period, they can adjust their rates up to a maximum. In some instances, they have not chosen to increase. In other instances, they have increased. I believe this year there was an increase added to it. So there are different mechanisms that can be used. Yeah. Either way, there's monitoring that takes place.
You're regulating the Barbados Water Authority now?
We are also regulating Barbados Water Authority, yes.
We've not heard anything, any rate increase from them, from none of you. Anything come to your attention?
So again, what we actively do at this point is standards of service for all three entities. No,
No application.
no application has come in from them. Yeah. So there's no economic regulation for Barbados Water Authority as well.
We do standards of
Standards
service
of service.
regulation.
Thank you.
Any other questions?
Okay, well, thank you all very much
Thank
for attending this press conference. And as you said, your copies of the decision is available?
Yeah.
Mhm.
You make sure you have the things.
Yeah. So thank you all very much.
Thank you. Take care.